Case. A patent! Ah! For many attorneys, patent law is a complicated morass full of technological jargon and mysterious technologies that's best avoided. You are not going to be one of those lawyers, because by the end of this unit, you'll understand what patents are and how they work. I'm going to demystify patents and introduce you to the foundational parts of patent law. Because really, at the end of the day, patents aren't that scary. Patents have been around for a lot longer than you might think. Let's travel back to 15th century Venice, the city of canals. At that time, Venice was the commercial and technological center of the Western world. Imagine yourself as a craftsman who's developed a new device for providing energy to water-draining machines, something that's very useful in Venice. It's a machine, so you're not sure that you'll be able to keep it secret for very long. So what do? Perhaps you go to your patron and ask him for help, and your patron gets together with other civic leaders to grant you a legal right protecting your invention from others who might copy it. Giving you this right both incentivizes others to develop new inventions of their own, in the hopes that they too might be able to get such an exclusive right, and helps recognize your contribution as the inventor of this new tool. Eventually, in 1474, Venice passed a general statute to regularize the granting of these protections over new inventions. Many of the elements of this 1474 Venetian statute are similar to those that are in patent law statutes today, granting exclusive rights over new and useful inventions. Over time, the concept of governmental grants of exclusive rights over inventions spread, for our purposes, to England, from which many of the early laws in the United States originated. In England, the concept was sometimes used to grant exclusive rights over entire products or markets, such as the grant of an exclusive right to manufacture and sell basic commodities like salt. The Crown sold these letters patent in return for money or influence. Think for a moment about this. Why would someone pay money for the exclusive right to sell salt in England? Well, because everyone needs salt. Not only does it make your food palatable, it's also needed for food preservation. By holding a monopoly on salt, the person with that exclusive right was able to charge a lot of money for access to salt. That makes that person very rich.
Here comes the money!
Here we go!
But what do you imagine other folks, particularly competitors and the public, thought about granting an exclusive right over the sale of salt? These people already knew about using and making salt. As you might imagine, when one person is granted a monopoly over a staple article of commerce, it makes their competitors and consumers very unhappy. Unrest over this process led Parliament to pass the Statute of Monopolies in 1624, which limited all letters patent. Legally granted monopolies were limited to inventions, new things rather than products that already existed. No more odious patents on salt or soap or playing cards. Instead, the justification for these letters patent was more akin to the original rationale underlying the Venetian statute, incentivizing the creation of new inventions. Over the next century, this justification expanded to also encompass the goal of incentivizing the sharing of information about new inventions with the public, a concept that we refer to as disclosure. Let's jump across the Atlantic now to the American colonies. Some of the colonies did grant patents through private legislative bills, but there was no general system of patent law. Following the American Revolution, in the period of the early American Confederation, the number of patents granted by states increased, leading to conflicts around patents. One state might grant a patent to one person for an invention, while another might grant a patent to a different person for the same invention. That leads us to 1787 and the drafting of the U.S. Constitution, specifically Article 1, Section 8, Clause 8, the Intellectual Property Clause, which grants Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This intellectual property, or IP clause, grants Congress the power to set up a system to grant inventors time-limited exclusive rights. The basic idea is that in return for disclosing the details of a new invention, the inventor receives the exclusive right to make and use that invention. The Constitutional Convention adopted the clause without objection or any recorded debate. Federalist Paper number 43, written by James Madison, offers some insights into the framers' thinking in adopting the IP clause. He noted that the utility of this power will scarcely be questioned, and observed that granting this power to the federal government, as opposed to the states, would help bring uniformity in this area. To effectuate these rights, Congress enacted the first patent statute in 1790, a statute that bears a striking resemblance to today's patent law. Here's the text of that first patent statute. It allowed the federal government to grant letters patent to the first and true inventor of any useful art, manufacture, engine, machine, or device, or improvement on them. The applicant had to provide a specification in writing describing the invention to enable a person skilled in the art or science to which it pertained to make, construct, or use the invention. In return, the patent granted the inventor the sole and exclusive right of making, using, and vending to others the invention. All of these remain essentially core elements of our modern patent law. Since that original act, Congress has made adjustments to the patent law, including creating a patent office to examine whether applications for a patent met the requirements for obtaining a patent, refining the rules for determining whether an invention is actually new, adjusting the term of the patent, and updating the language of the statute. Throughout the past 2 centuries, however, the core concept, an exclusive right to a new invention for a limited period of time in return for disclosing the invention to the public, has remained the same. In our next video, I'll talk about the core components and institutions of modern patent law. See you then!